Judiciary Committee will come to order. And we have quite a few conferees on our 3 bill hearings that we're having today, or excuse me, 2 bill hearings. So I want to make sure that we have time to hear from everyone as well as an opportunity to work some bills. So we're going to ask each conferee to limit his or her testimony to 3 minutes. And we'll use a timer for that purpose to help you keep on track. And with that, then, we will open the hearing on House Bill 2741, updating the general terms of supervision for offenders on probation and post-release supervision. With that, a bill brief from the reviser.
Thank you, Madam Chair. Good morning, committee. Jason Thompson, Office of Reviser of Statutes. You have House Bill 2741, hopefully the as amended by House Committee version, and a bill brief in your packet. I'll give you the quick procedural background. This was requested on behalf of the Department of Corrections. It was heard and worked by the Committee on Corrections and Juvenile Justice, amended by that committee, and then it passed the House on final action as amended, 119 to 0, it looks like. So this bill, broadly speaking, amends the 2 statutes about conditions of probation and conditions of post-release supervision. It removes the current list of supervision terms for offenders on probation and post-release supervision and makes those terms for each type of offender substantially similar. So you'll notice they're fairly consistent, although with a couple changes in terminology depending on the offender they're referencing. The bill also does, I wanted to point out, keep current law requirements that the person pay restitution, pay correctional supervision fee for those on probation, and administrative fee for those on post-release supervision, and also the requirement that they reimburse the state for expenditures made by BIDS, the Board of Indigent Defense Services, to provide them counsel. So those are maintained. I just wanted to mention that. So Section 1 is KSA 21-6607. That's the statute that provides the court may impose any conditions of probation, suspension of sentence, or assignment to community correctional services programs that the court deems proper, including but not limited to requiring that the defendant do all of these things. And as you see there, we struck the current law list and added a new list. And I'm going to go through each of those, but they're listed in both the bill brief and the bill itself. The main one I wanted to highlight is the one about searches. So these folks are subject to searches of their person, effects, vehicle, residence, and property by a court services officer, community correctional services officer, or any other law enforcement officer based on reasonable suspicion that the defendant violated conditions of supervision, probation, or engaged in criminal activity. So those are the kinds of searches they're subject to. And I highlight that one because it's different than the searches for those on parole or post-release. And so I'll explain those differences in just one second. Section 2, I'll just note, is an update to the cross-reference to Section 1 that's amended. So that's all Section 2 is, cross-reference update, no substantive change. Section 3 then is the statute about what happens when the Prisoner Review Board orders parole or establishes conditions of an inmate placed on post-release. This one, the board is required to do the things in the list. And again, I won't read those, but they're in the bill brief and in the bill itself. And I will just highlight that as introduced, the bill had a similar provision about searches as the one in Section 1, but as amended by the House Committee, it's more aligned with current law. And these folks are subject to searches under a different standard. So first of all, they're subject to searches of the person, effects, vehicle, residence, and property by a parole officer or a Department of Corrections enforcement, apprehension, and investigation officer at any time of the day or night with or without search warrant and with or without cause. So that's a condition in current law preserved in the new bill. And secondly, they're subject to searches of the person, effects, vehicles, et cetera, by any law enforcement officer based on reasonable suspicion of the person violating conditions of parole or post-release or reasonable suspicion of criminal activity. So that's more similar to the first section, but for these folks. I think that covers it. I'll just mention it becomes effective on July 1st if adopted, and I'll be happy to answer questions.
Thank you. Committee, any questions? Not seeing any. Thank you. We will invite proponent conferee Megan Milner, Deputy Secretary of Juvenile and Adult Community-Based Services, Kansas Department of Corrections. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, committee members. I'm Megan Milner, Deputy Secretary with the Kansas Department of Corrections. We are here to testify in support of this bill. Just a very brief history of how this came about. This work is the result of the Kansas Criminal Justice Reform Commission, which is a statutorily created body that was tasked with examining certain elements of the criminal justice system and providing recommendations for improvements. This body had support from the Council of State Governments, so they helped guide the commission through this process. One of the charges from the legislature to the commission was to review and consider the standardized terms and conditions for community supervision in Kansas. So the way things currently stand right now, you could technically have an individual who is on community supervision, so probation. They could be on court services supervision, and they could also be under parole supervision. So 3 different entities who are providing supervision services for individuals across the state, each having different conditions of supervision, really presenting some barriers sometimes for individuals to complete supervision. So based upon the recommendations of the commission, that recommendation was to standardize those between all 3 entities, which is what this bill would do. It does not eliminate the option for courts or the Prisoner Review Board to impose a special condition, so that is still an option, but it does just standardize these between all 3 entities that are providing supervision for individuals in the community. And again, this would apply to community corrections, parole, court services, also conditions that are imposed by the Prisoner Review Board. We are in support of this bill because it will help better align our supervision system in Kansas with evidence-based practices and hopefully set up individuals to succeed when they are on supervision. So that is all I will present. There's more in my testimony, which I'm happy to answer questions too, if there are any.
Thank you. Are there any other conferees wishing to testify as proponents on the bill? Not seeing any, then we will go ahead and open it up for any questions. Are there any questions? Not seeing any, then thank you very much for your testimony today. Appreciate you being here. And committee, are there any, this is a question actually for those of you online or in the committee meeting room, are there any neutral or opponent conferees wishing to testify? Not seeing any, then committee, you'll see we have neutral written only testimony from Kevin Waring, Legislative Chair, Kansas Association of Court Services Officers, and James Houston Bales, Senior Assistant Public Defender, member of BID's Legislative Committee. And with that, then, we will close the hearing on House Bill 2741. We are now going to open the hearing on 2605, increasing the maximum rate paid to appointed counsel for an indigent person, and ask for a bill brief from the reviser.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. You have, again, the bill brief, and the as introduced version of the bill has not been amended. Procedural background requested in the House Committee on Judiciary on behalf of the State Board of Indigence Defense Services. Heard and worked by that committee and passed the House on final action 107 to 12, 107 to 12. Essentially, this is a bill that increases the maximum rate paid to appointed counsel for indigent persons. The statute is KSA 22-4507. That's the statute that sets the compensation that's paid to the attorneys. Current law in subsection C provides that attorneys are compensated at the rate of $80 per hour unless the chief judge negotiates a lower hourly rate or the attorney has a contract with the board that specifies the rate paid. Those two exceptions are preserved, so the chief judge can still negotiate a rate and the attorney can still have a contract with the board. But the bill amends that subsection to provide that attorneys will be compensated at a rate not less than $120 per hour and not more than $140 per hour. So that's the change in the bill, upping the rate from $80 to $120 to $140. And I would note it would take effect on July 1st if adopted. I'll stand for questions.
Thank you. Can you tell us, by looking at statute, when the last time that the rate was changed?
Madam Chair, I do not have the legislative history at the bottom of the statute like I would if I was looking at it on
the website.
Or in the statute book. And I was looking to see if BIDS noted that in their testimony. I don't see it on first glance, but I bet they can tell you, and they should know.
We'll ask that question. Yes. Senator Steffen.
Thank you. So was it a year or two ago that we raised public defendants reimbursement rates up to 120? Is that correct? And apparently these folks weren't included.
Madam Chair, I don't recall all the financial aspects. I know BIDS has been in here a few times to talk about that, and rather than muck up I'm not an appropriations revisor for a reason, so I'm just going to back away from that one, and I'll let BIDS tell you what's been happening with their funding and with their attorney rates. Since it's their bill, I think they've got the information that I don't have.
And are there other questions for the revisor? We can ask the proponent about the history and the legislative history and appropriations. I'm sure they'll be happy to tell us. It's not seeing any other questions for the revisor. Thank you. And we will invite proponent conferee Heather Cessna, Executive Director of Kansas State Board of Indigent Defense Services. Please introduce yourself and welcome to committee.
Thank you, Madam Chairwoman and members of the committee for having me today. I am Heather Cessna, the Executive Director of the Board of Indigent Defense Services. I can go ahead and address some of the questions that were just asked before I get into my spiel a little bit. The last time our statutory rate was amended officially was in 2006, which was when it was set at $80 an hour. There was a period of time in about 2010, 2011, when our BIDS board had to cut that rate back by special provision because of shortages of funding. Then at that point, it went all the way back down to $62 an hour, although the statutory rate still remained $80 an hour at the time. So that has been in statute for quite a while. As far as your question, Senator Steffen, about the $120 an hour rate, we have been paying $120 an hour for the last 2 years in a row through special budget provisos. So we currently have the funding in our budget and into 2025's budget to support our $120 an hour rate, because that's what we've been paying through special budget proviso. Our interest in this bill is putting that rate into statute to provide some stability for our current attorneys who are serving on our assigned counsel panels. And just to be clear, that is a separate question than the additional funding for things like pay raises for our public defender employees, which are direct employees of the state and are provided through a separate funding mechanism that's not affected by this statute. So our reason for coming here today is essentially because of the shortages of counsel that we have been suffering across the state. As a result of that, several years ago, our board started looking at what we needed to do to better support our attorneys who are out in the field who provide defense services through the appointments process on our assigned counsel panels. And one of the first things that we did to try to address that was to look at the low rate of pay. And we've been successful as a result of those increases. For 1 year, we went up to $100 an hour. For the last 2 years, we've been at $120. That definitely, especially during the pandemic, helped us maintain people on our panels. in order to take private appointed cases from bids. Our hope with the wording of this statute is that we continue to support our current people on our panels that are serving on these cases. And then it also gives us the ability in the future, if our bids board was to support a additional increase, and if we were to be able to gain the financial backing from the legislature to support a future increase, to potentially go up as high as $140 an hour. I will tell you right now that we already had requested funds for $140 an hour in our budget this year. That was not recommended by the governor or by either of the houses in the current budget bills. So that additional rate increase for this year is kind of off the table at this point. So, but it would allow us in future years, if we continue to see a need to try to bring in additional individuals to serve on those panels, the opportunity to look at future requests for an increase. I certainly can answer any questions that you might have, but we would appreciate your support of this bill.
Thank you. Next, we will hear from Joseph Molina, Director, Legislative Services, Kansas Bar Association. Please introduce yourself and welcome to committee.
Hello.
It's been so long since you've testified here, you forgot to how to work the microphone. So
I'm a rookie.
Thank you.
Joe Molina with the Kansas Bar Association. I appreciate the time setting the hearing and discussing House Bill 2605 with the committee. We met with BIDS and Heather Cessna for the last several years, and it became quite apparent really early on that there's a bit of an issue with defense counsel, with probably lawyers in general in the state of Kansas. And this is just one of those ways so that we can support this sector. In my testimony, you'll see that in 2017, the KBA came out with our economic survey of law. Basically, we go out there and we survey as many lawyers as possible. I believe we sent out over 10,000 surveys to the lawyers in Kansas. And the information that came back was basically that for a private criminal defense counsel, the hourly rate is about $225, which is a significant deviation from what is currently on statute of $80. And so just increasing that helps keep people on those panels. And those panels for criminal defense is voluntary. So if the number drops too low, then we could see a decrease in number of people that are actually going to be out there helping. And if you don't have criminal defense counsel, it's very hard to get some of those criminal cases through. You're going to be hearing from the prosecutors here in a second. I'm sure they have some of their own thoughts. But this is just one of those ways to support that sector and make sure that criminal justice in the state of Kansas continues. And the KBA really supports House Bill 2605. I'd like to reserve some of my time if you guys have questions for Heather Cessna, since she's the technician and she understands the budget process a lot more than I do with bids. But we're here just to say that we appreciate the hearing, and if we can do anything, just please let us know.
Thank you. Next, we'll hear from Jeff Wagaman with the Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Good morning, Madam Chairman and members of the committee. I am Jeff Wagaman from Steve Kearney and Associates, representing our client, the Kansas County and District Attorneys Association. This professional association is dedicated to the administration of justice, to promote, improve, and facilitate that in Kansas. The KCDAA is very proud to support 2605, quite simply because it's the right thing to do. It is very important for defendants to have good criminal defense attorneys, and we think this measure is perhaps long overdue, but certainly the right thing to do. As has been talked about, I think as many of you are aware, there is a shortage of attorneys in Kansas. This shortage affects both the defense counsel and prosecutors, in fact. We think this bill will help indigent persons have better access to defense, which will help move trials and cases through the system. It is very common for cases to be continued or delayed because of lack of counsel. That's not a good thing because it delays the system, it delays the entire justice system, and in fact, it delays the outcome of a trial, which can be burdensome on victims of crime. That's why the KCDA is very supportive of this. We're happy to be here today. We've been able to work twice this session with the with the defense, and we're very proud to stand in support of this measure. I'd be happy to take questions at the appropriate time.
Thank you. Are there any other conferees wishing to testify as proponents on the bill? Not seeing any, then we'll go ahead and open it up for any questions. Senator Wilborn.
Thank you, Madam Chair. This question I think I know the answer to, but I would like to have Mr. Wagman come back to the podium briefly. And the question is very simply this. Do you see a huge disparity in the shortage of both prosecutors and defense counsel across the state? More what I'm driving at, the rural areas, it's worse, I assume.
Yes, it is. And I was just talking to Heather Cessna about that. I think it's the Chief Justice has set up a committee, a council to look at the lack of representation out in Western Kansas or the areas of lower population. And it is a problem. I know there are, because one of the good things to come out of the pandemic, if there was one, was two-way video and the ability to have some of these procedures done online by video. And so that has helped. But there is definitely a shortage all across the state.
Thank you. Committee, other questions? I have a couple of questions for Heather. Thank you, Jeff. I appreciate that. For those following along online or who might otherwise not know, could you describe just very briefly, when you mentioned private panels of appointed counsel for indigent persons, how constitutionally, if you're charged with a certain level of crime and you can't afford an attorney, one will be appointed for you, and then talk about those private panels. Just briefly describe the process of why this bill might be helpful as you've been talking about.
Sure.
And go ahead and introduce yourself again, please. Thank you.
Heather Cessna with the Board of Indigent Defense Services. So the Sixth Amendment, as applied to the states through the 1963 case Gideon versus Wainwright, required that indigent people have the opportunity to have criminal defense counsel assigned to them to represent them in cases where otherwise before that they were not necessarily entitled to that. As a result of that, the states have an obligation to provide that counsel. BIDS does that specifically for felony adult criminal cases. And our mechanism to do that is kind of twofold. We have, on the one hand, a series of public defender offices throughout the state that are direct employees of our board that represent individuals. Those tend to be in the more populated areas where there are higher percentages of cases. But every single county has a private appointments list, even where we have public defenders offices, to provide counsel in cases of conflicts or co-defendant situations, or just because of shortages of counsel in the public defender's office. And then for those counties where there isn't a public defender's office, it's the only method of appointment of counsel. And that is made up of private attorneys who agree to take reduced rate cases at the BIDS statutory hourly rate or through a contract to provide those defense services. So it's our way of providing that constitutionally mandated public defense.
Thank you for that explanation. And when you say private, you mean they are not employees of the public defender's office, or?
Correct. So they're
Yes.
usually
They're in private practice on their own, and they
Right.
have volunteered to be on this list to be appointed as cases come up and as the needs come up from BIDS.
Yes. And as a result of that, they frequently are not taking their entire caseload from our appointments panels. They're usually taking other paid cases to supplement their income. So the amount that we're paying in our hourly rate makes a big difference on the number of cases that they can actually afford to take.
Thank you. Senator Stephan.
Thank you. Can you give me an idea of what a paying customer who's a defendant, what the attorney makes?
If you were a private person charged with something like a high-level felony, you'd probably be paying upwards of $350 to $400 an hour for a private criminal defense firm in Kansas. So this is still a severely reduced rate.
Thank you. Committee, any other questions? Not seeing any. Thank you very much for being here. Appreciate it.
Thank you.
And do we have any conferees wishing to testify as neutral or opponent? Not seeing any, then we will thank the conferees for their testimony and their appearance today and close the hearing on House Bill 2605. And I had said earlier we were hearing two bills today. On the agenda, there are three. So I'm now moving on to the third one. Hearing on House Bill 2353, increasing the amount of time a person may be held for treatment and adding criteria for when continued treatment may be ordered under the Care and Treatment Act for mentally ill persons. And a bill brief from the reviser.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. As you mentioned, House Bill 2353, you should have the as amended by House Committee version, a bill brief. It is the bill about Care and Treatment Act for mentally ill persons. The procedural background, it was requested in the House by a representative on behalf of the Kansas Department for Aging and Disability Services. It was heard and worked by the Committee on Corrections and Juvenile Justice last year, and then heard and worked again this session before being amended and passed out of committee. It went to the floor and passed on final action in the House 119-0 and made its way over to you. As I mentioned, these are all amendments contained in the Care and Treatment Act for mentally ill persons. That's found in Article 29 of Chapter 59 up in the probate area. I'll briefly highlight all the sections for you. I won't go into too much detail because you've got a lot of folks who want to speak and I don't want to take up all the time. Section 1 amends the statute in the Care and Treatment Act about ex parte emergency orders. I explained in the bill brief kind of the mechanics of the 5 p.m. on the second day the district court is open. This changes it from expiration on the second day to the third day. So I've kind of underlined second to third. That's the change in Section 1. Section 2, similarly, is a statute in the Act related to temporary custody orders. Again, the change from the second day the court is open to the third day the court is open for expiration. Section 3 gets a little more attention because it's the focus of some of the testimony you're going to get and connects back to the AOT program you heard about earlier this session in an informational briefing that and I'm going to get the acronym wrong if I don't look at it, assisted outpatient treatment. The committee received a briefing on that, and there's some testimony on that coming up. Just wanted to kind of make that connection for you. That's what we're kind of talking about in Section 3 a little bit. There's a current law provision in subsection A that you can be ordered to have outpatient treatment at any time in lieu of another type of order that would have required inpatient treatment if the court makes certain findings. So as amended by the House Committee, those findings are changed in the bill. And I'll just highlight the findings you'd be required to make under the bill as amended would be that the patient will meet the criteria for required inpatient care and treatment in the proximate future without such outpatient treatment, and is only likely to attend outpatient treatment if there's a court order mandating such treatment, or a finding that the patient is, if left untreated, reasonably expected to experience an increase in the symptoms caused by the illness that would result in the need for inpatient care and treatment in the proximate future, and whose mental illness has previously caused the patient to refuse needed and appropriate mental health services in the community. So you can see that's a difference from the current law that's pretty substantial and has a lot of policy implications. And I think that's why you're being asked to make that change to facilitate these new programs. There's also an amendment about in subsection E about ex parte emergency custody orders. They expire on the second day the court is open now. It become the third day the court is open under the amended bill. Subsection F, again, second day to third day, that changes in there related to when you take a person into custody under an emergency custody order and you order involuntary inpatient care. So there's an extra day that the order would be in effect. Finally, Section 4 is the statute in the Care and Treatment Act about hearings to review the status of patients. I note that current law in subsection F talks about the hearing and the clear and convincing evidence finding by the court and continued involuntary commitment and continued treatment. The current law is that a specified period of time for extension is not to exceed 3 months for any initial order, nor more than 6 months in any subsequent order. The bill would amend that to allow the treatment to be ordered for not to exceed 6 months for an initial order for continued treatment, and continue the no more than 6 months for any subsequent order. So the initial order goes from 3 to 6 months. That's the big change there that you're asked to make. I think that covers the highlights. Be happy to answer questions and stand aside for the conferees.
Thank you. Committee, any questions? Not seeing any. Thank you. We will invite proponent conferee to the podium, Stephen Green, Dugan Consulting, on behalf of Cicero Action. Please introduce yourself and welcome to committee.
Good morning, Chairwoman Warren and members of the Senate Judiciary Committee. This is actually the first time that I've testified in this room and in front of you all, so I appreciate the opportunity specifically to weigh in on this bill as proponents on behalf of Cicero Action, which is a nonprofit, nonpartisan advocacy organization that identifies innovative and effective policy reforms in different states across the country. You're going to hear from multiple proponents on why we think this is a good piece of legislation. And so I'll leave a lot of the more of technical explanations to some of the other conferees. Really, where we fit in and have been, why we think this is great policy is addressing specifically an issue that's been in front of the legislature and been talked about often in the media, which is the homeless or unsheltered population. This, we really do think, is a good tool and sensible change to improve the accessibility and effectiveness of the state's mental health care. In my testimony, just note that there is approximately just 300 inpatient psychiatric beds in the state. That overall has dropped by 56% since 2010. So you really see a shortage of inpatient psychiatric beds. And in addition, and you've seen this or maybe noticed this, a rise in what we would consider sometimes classified as unsheltered homeless. When you think of unsheltered homeless, that term, you think about if you were just to go north of on Kansas Boulevard or Topeka Boulevard, look across the north bank of the river, and you might notice, even though the city's has been enforcing ordinances, a large what we call homeless encampment. These individuals are not only what we would say often addicted to various substance use disorders, severe mental health issues, but they're also a vulnerable population. Just recently here in Topeka, where I'm from, I actually, my dad retired from the Miniger Clinic, grew up across from the state hospital here, so sort of had an awareness of this issue. There was an individual that was actually had a series of known mental health illness, severe mental health illnesses that was carrying their bike up a busy part of a highway and actually was hit by a car and was and died as a result. This person was known to have severe mental health illness or mental health issues within our community, and this type of legislation we think could have, if it was in law, could have at least been a tool that the courts could have used, and it may have helped that person and prevented that outcome. The unsheltered homeless population, again, think of homeless encampments, has increased. It's increased by 85% in the last 5 years here across the country, but also in Kansas specifically. And that growth is a result of several factors, including severe mental health illness. So we think that this adding additional clarity in the current state statute is a good policy, something that you all should consider, and happy to answer questions at the appropriate time. Thank you.
Thank you. Next, we will hear from Susan Crane Lewis, President, CEO, Mental Health America of the Heartland. Please introduce yourself and welcome to committee. Make sure the microphone is on, the light. There you go.
There we go. Good morning, Chairwoman Warren and members of the committee. My name is Susan Crane Lewis. I'm the President, CEO of Mental Health America of the Heartland, which is a mental health advocacy organization founded by a psychiatric patient in 1909 as the oldest civil rights organization in the country. I come before you today in very strong support of House Bill 2353, as I did last month when it was heard in the House Corrections and Juvenile Justice Committee. This is a marked change. When the bill was originally drafted last year, my organization was prepared to testify in strong opposition to the bill, as language in that version needed to be made more specific, particularly as it related to physical, mental debilitation in the patient, in order to avoid eroding the civil liberties of the 1 in 4 Kansans who have mental illness. Please know that I and my organization were and are not categorically opposed to involuntary treatment, but that it must be a last resort and invoked only when an individual is in imminent or danger of significant harm to themselves or others. And in these cases, full due process must be afforded to the individual with alacrity. You may be aware that over the intervening months, a small group of very dedicated individuals representing multiple interests and perspectives spent significant time in dialogue, researching and crafting alternate language, and coming to consensus on language that addressed the concerns of all parties. That's the language that is contained in the bill you have before you today. We know that court-ordered outpatient treatment has been found to be a suitable and effective alternative to involuntary commitment in many cases. It saves both the court and the provider time and money while preserving the rights and dignity of people in need of intervention and allowing them to be treated in their own communities with the supports, both formal, informal, that they need to recover. The bill before you provides clarity and appropriate guardrails and due process while enabling the court system and providers to effectively use this option to serve Kansans in imminent and urgent need of mental health treatment. I respectfully request the committee pass this bill so that good legislation that assures that people who require involuntary treatment receive it with minimal harm to their civil rights and to their dignity can be passed by both chambers this session. I will stand for questions at the appropriate time. Thank you for your time and your attention.
Thank you. Next, we will hear from Chris Schneider, Assistant District Attorney from Wyandotte County. Please introduce yourself and welcome to committee.
Thank you. Good morning, Chairman Warren, members of the Senate Judiciary Committee. My name is Chris Schneider. I'm an Assistant District Attorney in Wyandotte County. I've been an Assistant DA in Wyandotte County for 37 and a half years. And for the last 15, I've handled our mental health or care and treatment docket, which Sue referred to as the involuntary commitment docket. I was part of the group that worked over the last year on refining the language and that we came up with and the revisor put together for us. Outpatient treatment is a terribly urgent and a terribly important tool to deal with mental illness in our state. It's a tool that allows us to avoid committing people to a hospital, a state hospital or a private hospital that will take them, the SIAs and that exist. We know from experience that every time we send somebody to a mental hospital when they slip, getting them back to where they were before is very, very difficult. They're probably not going to get back there. If we could avoid sending them to an inpatient facility, it's better for those who are suffering from mental illness. It's also better for our community as a whole, for their state as a whole. Obviously, it's less expensive to have someone on outpatient treatment orders and be supervised in the community than have them in a bed in a state hospital. Our goal when we file a care and treatment case is to get somebody back into the community as quickly as possible, get them stabilized, and ideally, at least in the short term, get them on outpatient treatment orders. The time adjustments in the statute allow us to do a better job of that because we're not rushed. We can take a breath. And sometimes we have folks, and we had a case just a couple weeks ago in Wyandotte County where we filed on someone because they expressed suicidal ideations. By the time we came to court, that person was fine, and the case was closed. Had we had the extra day, that person probably would have been stable, and we wouldn't have filed in the first place. So the time, it gives us the time to breathe, to intervene, if you will. And those who are that we're seeing, I noted in my written testimony, just in our county, as of last Friday, we are on a pace to see almost a 1/3 increase in filing of care and treatment cases this year. We don't have the bed space in the state hospitals or in private hospitals to address all of those folks the way they should be addressed. We can throw somebody in for a few days and say, oh, we're addressing it, but we're not, because sometimes it just takes more. And outpatient treatment orders allow us to do that.
We've hit our 3 minutes, but please, for our conferees, remain in the room if you're available to stand for questions after we hear from all our proponent conferees. That would be great.
Certainly, Senator Warren. Thank you.
Thank you. Appreciate it. Next, we will hear from Drew Adkins, Commissioner, Behavioral Health Services, Kansas Department for Aging and Disability Services. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, members of the committee. Drew Adkins, Commissioner for Behavioral Health Services at the Kansas Department for Aging and Disability Services. I will keep my comments brief. I know that you have already heard powerful testimony. I think there's probably more yet to come. We are very thankful to be here again and thankful that the committee is taking this up. Just to reiterate a couple of points from our perspective, House Bill 2353 was requested by KDADS in conjunction with the AOT, Assisted Outpatient Treatment Grant, that we have from SAMHSA, the Substance Abuse and Mental Health Services Administration. We saw from that we felt we needed to do more. We got together, as you heard, with stakeholders that we felt like knew this and have been working in this for quite some time. I believe that we met for a year, maybe a little bit over a year. And I think that we came up with a pretty good product, and I'm excited about that today. AOT, just as a quick definition, is a program that utilizes outpatient treatment orders to help those with serious mental illness, schizophrenia, bipolar, and schizoaffective disorder who have a repeat history of hospitalization, medical non-adherence, and many times do not realize that they are ill. It's important to note as well that AOT is a civil court intervention that, in conjunction with the local mental health centers and certified community behavioral health clinics, ensures that the participant receives the services that they need and that the participant is required to participate in their treatment. Just to go over a couple of the changes that have been mentioned, we are asking that for the extension of the ex parte emergency custody order from 2 days to 3 days, adding decompensation standards to the outpatient treatment order criteria, providing the directives and treatment plans to the court, and extending an initial outpatient treatment order from 3 months to 6 months. I think it is also important to reiterate and echo something that the last conferee said, that we really are trying to do all this to keep individuals from having to go to a state hospital. If we can keep individuals and consumers in the community that they live, we do see progress. We do see a lot of forward momentum there. It does take a lot of time and what we hear back from our licensed providers to get them back to status quo. And so with that, the last thing that I would say is I just want to thank all of the many stakeholders that we worked with. Just to name a few, we had an AOT judge out of Johnson County, Judge Winnell, that helped. We also had a district attorney office, Wyandotte County. You just heard from that individual. The Association of Community Mental Health Centers, who I believe also were testifying in support of this, the Disability Rights Center, and Mental Health of America, the Heartland. I'm happy to stand for questions at the appropriate time.
Thank you. Appreciate it. Next, we will hear from Nick Hart, who's a private citizen. Please introduce yourself and welcome to committee.
My name is Nick Hart. I'm in support of House Bill 2353. I have 4 kids. My oldest son, Gus, is 32 and has bipolar disorder type 1. He further carries the designation of having severe and persistent mental illness, having been hospitalized over 30 times since his condition was diagnosed over 13 years ago. He has been living with us for most of his adult life. We are a close, tight-knit family with a family business. We spend a lot of time together and also in the community. Gus is intelligent, charming, hardworking, and good with people. He is adored by his nieces. But with his condition, his mental health will cycle every 6 months to a year. When he is amping up on a cycle, he can go from hypomania, which is an elevated mood, to psychosis in less than a week. Allowing the treatment prior to psychosis would help our family out tremendously. He has frequently been caught in the loop of being himself in a threat to himself or others criteria for getting into treatment. My firsthand experience with a loved one going through mental health crisis is analogous to a house fire. The sooner you get intervention, the better the outcome will be. If a person is allowed to become psychotic or a threat to themselves or others before getting treatment, it will take weeks or even months for the person to stabilize. It is heartbreaking as a parent knowing that your son needs treatment, but it does not meet the screening criteria. In January 2023, Gus was experiencing a severe psychotic episode. He was involved in a high-speed automotive accident, and he suffered extensive injuries and was actually in the intensive care unit for 12 days and was in the hospital via Christie in Wichita for over 100 days. And after that, he was in a level 2 mental health nursing home for over 6 months. Thankfully, no one else was injured during the accident. However, the scenario could have played out with innocent people and law enforcement officers being injured or even killed. This type of psychotic episode and outcome can be avoided with early intervention as detailed in House Bill 2353. I agree that adding the standards outlined in House Bill 2353 will enable mental health facilities and judicial courts to intervene before a mental health issue becomes a crisis. Passage of the bill will positively change the lives of families that have loved ones with SPMI. Further, quicker intervention will help law enforcement officers and improve community safety prior to mental health escalations. And I would further invite everyone here to read the National Review article "To Help the Mentally Ill Help Their Families" by Stephen Idy. The article carries the byline, "How to Correct the Excesses of Deinstitutionalization." The article is very good about what it is like to live with someone with severe and persistent mental illness. I ask for your approval of the requested changes outlined in the House bill. It will provide hope to me, my family, and numerous families throughout Kansas who go through the same struggles. Passage will also help Kansas law enforcement officers and can make Kansas communities safer. Thank you.
Thank you, Mr. Hart, for appearing today and sharing your personal story with committee. We appreciate it.
Thank you.
Committee, I'm going to ask, are there any other conferees wishing to testify as proponents on the bill? Not seeing any, then are there any questions for our proponents? Senator Haley.
Thank you, Madam Chair. I'm certainly supportive of this measure. Mine was really to not a question so much. Well, I guess it is a question of either Chris Snyder or Susan Crane Lewis. Chris and I actually were assistant DAs together in Wyandotte County. He's still there in the position holding down the fort. And Susan Crane Lewis has been very active up and down Minnesota Avenue there with the firm that she was with, the company she's with, and have been taking care of the mental health needs for between the two of them on both sides for a long time. My question is, both testified there's a pending increase. I go through KCK quite a bit, but you project that there's an increase that will be felt, I guess, in the regions that we represent. Why is that? I mean, why is it disproportionately so? Is it bleed over because of Missouri, or can we pinpoint why there's a disproportionate number of increase or need for this extension, more so in our area or in the area that you serve?
Senator Haley.
Make sure you introduce yourself again. Thank you.
Chris Schneider, Assistant Wyandotte County District Attorney. Senator Haley, I don't know that it's an increase. I think it's greater awareness. Over the last number of years, the awareness of mental illness has increased, and some of the stigma that's attached to mental illness has decreased. We've also done a great deal of training with law enforcement in not just in Wyandotte County, but in the whole metropolitan area. CIT training for officers, some of the training that Mental Health America of the Heartland has done across the state of Kansas, because they have, and I sit on the board of Mental Health America of the Heartland also. They have contracts to do some of that training throughout the state of Kansas. And I know Sue and some of her other staff go out across the state about 4 times a year and do that. So there's a greater awareness of mental illness. And also, law enforcement has discovered through their training that sometimes the answer is not to take someone who is experiencing the symptoms of mental illness. We don't default take them to jail. For a long time that happened. But our correctional institutions, jails and prisons, are not well equipped to deal with folks who are mentally ill. They don't have the training to do that. We divert some of those folks from the criminal justice system into the mental health system, and it's better for everyone, because the crimes they're committing, oftentimes, now, sometimes they are very serious, but oftentimes they're not serious. Oftentimes they're trespassing, they're urinating in public, they're panhandling, or just annoying people because they're in their face shouting and talking. They're not necessarily threatening people. They're just being a nuisance. And that doesn't necessarily require jail if someone is suffering from a mental illness. By getting those folks into the mental health system, it's better off for them. It's better off for the community. It's better off for law enforcement.
I appreciate it. Thank you so much. Ms. Crane-Lewis, I don't know.
I would
Please go ahead and introduce yourself again.
Oh, sorry,
Thank you.
Susan Crane-Lewis, Mental Health America of the Heartland. I would concur with everything that Chris Schneider has stated. I would also note what I think is a wonderful and difficult trend that I have noticed over the past 26 years. 26 years ago, when I started working at Mental Health America, folks who had major mental illness didn't live as long as they do now. We have increased the lifespan of those folks through a lot of the wonderful work that is being done in community mental health centers and community CCBHCs to deal with the medical stuff. What happens then as a result, though, is many people have maintained in their family of origin, which works really well until mom and dad are 70 or 80 and the person's 20 and the rest of the family's gone. So I think a number of the informal supports simply have aged out for some people. And I think that is part of what is resulting in folks coming into the public system, as well as the stigma reduction that I, at least in my organization, have worked for 26 plus years, or 1909, I can't do the math, a really long time to eradicate. So I thank you for the question.
And I thank you, Ms. Crane-Lewis, and I thank you, Chris Snyder, and thank you, Madam Chair. I've worked with each of them before in Wyandotte County and around, and these seasoned professionals really are making a difference in addressing some of the mental health and other needs in our community. And I thank you, Madam Chair, and both of them.
Thank you. Next, Senator Steffen.
Thank you. Susan Crane may be perfect for this question. I'm gonna put on my devil's advocate hat here and understand. Did I hear a groan? Thank you. You know, we're living in a time where right now the federal government's being looked at by the Supreme Court for suppression of information. We've got a Supreme Court justice who is making statements anti-First Amendment, and I'm looking at a bill that's wanting to lock people up involuntarily, unless I've interpreted this wrong, from 3 months to now to 6 months. So I am concerned of the potential misuse of this. With that being said, help me become more comfortable. Bring me the studies that show that involuntarily holding somebody against their will for 6 months statistically results in better outcomes than 3 months. Thank you.
If you'll go ahead and introduce yourself again,
yes,
please.
Susan Crane Lewis, Mental Health America. And I am smiling only because this is one of the fights that I had with the group. and we're not talking about involuntarily holding a person like in the state hospital or a state institutional arrangement. We're actually requiring them to seek medical attention, psychiatric medical attention, mental health medical attention. And what we're saying now is, rather than saying, hey, you know what, you're really struggling, you got to go to the doctor, whether you want to or not. You got to go to the doctor, and you're going to go to the doctor for 3 months, and the doctor's got 3 months to either get you fixed or to get you convinced that you should stay with the doctor voluntarily. What we know is that there is this tipping point there where for some point, folks, it might be 3.5 months, it might be 4 months. And there's some folks, and I will beat the medical analogy to death because some of these people are in my family, where, okay, I'll go for 3 months. Tick-tock, 3 months is up, I'm done. I'm out, I'm not doing anything because my 3 months is out. Whereas a little more time would have enabled either A, the treatment to really take hold, or B, the person to get more invested in getting that treatment.
So I'm going to take from that it's more observational than it is study proven.
I am going to defer to the folks who fought with me and brought all those studies forward that convinced me.
If I may, it certainly reads to me that this is at an inpatient treatment facility.
No, the statute changes are about having a person go to outpatient treatment in their community in lieu of being committed to a state psychiatric facility or institutional alternative. This is absolutely a diversion. And the criteria are very specific. And again, we worked, and some of us kicked and screamed and fought really hard on making sure that a person really, really did need to be required to get that treatment.
Again, Paul, I would love to see the studies that aren't just observational.
Okay, can I, or can you call maybe?
Sure. Is there another conferee who can answer that question about studies?
Okay.
Sure. Please go ahead and reintroduce yourself. Thank you.
That's Drew Adkins, Commissioner for Behavioral Health at ks. We're working on getting that information, so we're happy to follow up on that. I think we probably have a decent amount of that, Senator.
Thank you. Senator Baumgartner.
Thank you, Madam Chair. I just would like a clarification that this is only for individuals 18 or older.
Okay. Which conferee can answer the senator's question? Please go ahead and reintroduce yourself. Thank you.
Drew Adkins, Commissioner for Behavioral Health at ks. That is correct, Senator Baumgartner.
Thank you. Committee, any other questions? Not seeing any. Then are there any other conferees wishing to testify as proponents on the bill? Not seeing any. Then committee want to direct to your committee documents some proponent written only testimony from Itzel Moya, National Alliance on Mental Illness, Kansas Assisted Outpatient Treatment Project Director, Isaac Johnson, NAMI, Kansas Resource Line Director, Christopher Chastain, Public Policy and Advocacy Director, NAMI, Kansas, Susan Wallace, NAMI, Topeka, Rhonda Melton, LMSW, and Assisted Outreach Coordinator, Clinician for Cowley County, Andrew Stein, District Judge, 16th Judicial District, Lane Williams, Legal Director at the Disability Rights Center of Kansas, Michelle Ponce, Associate Director for the Association of Community Mental Health Centers of Kansas, Connie Hart, private citizen, and Anna Rose White, private citizen. Are there any conferees wishing to testify as neutral or opponent on the bill? Not seeing any, then we will go ahead and close the hearing on House Bill 2353. And while we are here today, committee want to work a few bills. And the first one we will take a look at is House Bill 2604. And if you'll recall, 2604 increases the jurisdictional limit for small court claims. And with that, then a review from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. As you mentioned, House Bill 2604 increases the maximum dollar amount for a small claim from $4,000 to $10,000.
Thank you. Committee, any questions for the reviser? Not seeing any. Is there any discussion, or I'll entertain a motion? Senator Stephan.
I'd make a motion that we pass this bill favorably and place it on the consent calendar.
There's a second from Senator Baumgardner. Sorry, I was looking that way, Senator. Committee, any discussion? Senator Haley.
Thank you, Madam Chair. And maybe you can stay on the consent calendar should this pass. I needed clarification about the process. I visited with Mr. Thompson about it. I won't make the amendment at this time. We have a concern with jurisdiction for small claims courts as to where small claims actions, as to where they can be filed. We've had problems, certainly in Wyandotte County, that these small claims actions have to sometimes be filed where the defendant is filed, and that can be even another state like Jackson County. I do appreciate this. I do support the bill. I certainly think it is consent calendar worthy. And if Mr. Thompson advised me that this is not where we clear up that discrepancy, then as far as I'm concerned, it'll stay on the consent calendar.
Thank you. Mr. Thompson, do you have an answer regarding, I suppose that would be venue and jurisdiction?
Sure. Thank you, Madam Chair. Jason Thompson, Revisor's Office again. So worked with Ms. Nelson from research and did some research on this issue after it was raised in the hearing. There is a current statute in the Small Claims Act. It's KSA 61-2708 related to venue. And it does have a provision that says the county in which the cause of action arose is the proper venue only where you affirmatively show the defendant was a resident of the county where the cause of action arose at the time the cause of action arose. So essentially, if you have a defendant who was there and was a resident at the time, you can maintain the action against that person even if they've now moved. But if, for example, you have a person who does not live in the county that committed the act or came into the county and committed the act and does not reside there, venue is not proper under the Small Claims Act. Now, that's not to say venue is not proper under a limited action, which is the next step up, or under, of course, our civil code, a full civil action. But those all come with lawyers, expenses, et cetera. So to the senator's point, the small claims being foreclosed is a policy issue that has been addressed. Ms. Nelson found some information indicating that change was made some number of years ago, 1994. There was a subcommittee and a Judiciary committee that worked on a bill that tailored that provision. It used to be more restrictive in the past, I believe. So this was a step to allow some actions to be maintained even if the person lived there and no longer lived there, but it still doesn't allow it if somebody never lived there or doesn't live there when the cause of action arose. So all that to say, not a statute in the bill, is in the same act. Not sure what the policy choice of the committee would be, but we have a lot of information that we've given you, and it might be an issue worthy of further study if we're interested in pursuing it, but it's up to the senator about how he wants to proceed right now.
Thank you. Senator Haley.
Thank you, Madam Chair, and thank you, Jason Thompson, for the review. Just 2 sentences. I do support this bill. I will support it with the consent calendar, but just by way of example, if one lives in Kansas City, Kansas, if a plaintiff, and these are all pro se actions, you can't hire an attorney for small claims. But right now it's $4,000, and an unscrupulous contractor who lives in Jackson County, Missouri, Kansas City, Missouri, that contractor comes to Wyandotte County, contracts in Wyandotte County for less than $4,000, and then goes back to Jackson County, Missouri, and the claim now, the plaintiff has to go pro se without an attorney over to Jackson County, Missouri for less than $4,000, can't hire an attorney, and is basically out if they can't navigate the Jackson County, Missouri, or the Missouri statute on this. And now this will raise it to 10,000. So they'll usually be ripped off for even more, is what happens in small claims with these particular matters. And I've seen 3 examples in the last year. I do appreciate those legitimate claims, but I do want to raise that issue that's my consternation with raising it, because there are interjurisdictional venue problems for the filing of these actions. I do support the underlying bill, though, and thank you, Madam Chair, for your patience with me on this, and again, for Mr. Thompson's clarity on it.
Thank you for bringing the questions to committee, and Mr. Thompson for the response. If we have all that kind of cleared up, or at least responded to by the revisor, is there any other discussion on the motion? Not seeing any, then you all have heard the motion to pass 2604 out of committee favorably for passage and place it on the consent calendar. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, next I'd like to take a look at 2628, requiring the Secretary for Children and Families to release certain information related to a child fatality when criminal charges are filed alleging that a person caused such fatality. And with that, a small brief from the revisor.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. And as you said, this is the bill from the Kansas Department for Children and Families. The Secretary testified about the other day. The current law only allows release of certain information, and likely, and as interpreted by the department, requires a finding of abuse or neglect before that information is released by the department. The bill makes it clear that criminal charges being filed with a court alleging a person caused a child fatality would allow them to release the information. So it would allow them to release information earlier and without making those findings if a court filing is made.
Thank you. Committee, any questions? Not seeing any. Do we have discussion or motion? Senator Olson.
Thank you, Madam Chair. I move that we pass out House Bill 2628 favorable for passage.
Thank you. And a second from Senator Baumgartner. Committee, any discussion? You all then have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Next, let's take a look at House Bill 2660. And that is modifying requirements related to certain business entity filings with the Secretary of State. And a short bill brief reminder from the revisor.
And again, thank you, Madam Chair. Jason Thompson, Revisor's Office. Hitting my microphone. Sorry about that. Is anybody listening along? House Bill 2660 came to you from the Secretary of State's office. They were here to testify as the proponent. It changes a number of business entity filing dates, some issues with fees, information that's reported to the office, essentially a bunch of business practice upgrades to deal with their new software and some related matters. That's probably enough.
Thank you. Committee, any questions? Senator Steffen.
What was the vote in the House?
Madam Chair, the vote was 120-0.
Thank you. Committee, any discussion or motion? Senator Olson.
Thank you, Madam Chair. I think this is a great bill, modifies the business code. We've been going that direction for the last couple of years, and I've kind of used it this year for the first new modern on the new technology. So I'm going to make a motion to pass out House Bill 2660 favorable for passage.
Thank you. And a second from Senator Steffen. Committee, any discussion? You all? Yes, Senator Steffen?
Would the carrier of the motion be willing to put this on the consent calendar?
Senator Olson?
I mean, we can, but, we need something to carry across the floor, right? A lot of times they get pulled off this late date, but if you want to put it on the consent calendar, I'll do that.
It's up to you. It's your motion.
My motion will say that.
Okay, then we've keeping the motion as is with the second. Do I have that correct?
Put it on the consent calendar.
Thank you. So you withdraw your motion and make a substitute motion.
Yeah, I move that we pass out House Bill 2660 favorable for passage and put it on the consent calendar.
Thank you. And Senator Steffen, do you withdraw your prior second of the prior motion and second the substitute motion? That's a yes. Thank you. Any discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, want to take a look before we adjourn at one last bill for today, and that's House Bill 2487, providing immunity from prosecution for certain drug crimes when persons seek or provide medical assistance related to the use of a controlled substance. Any discussion on the bill or a motion? Senator Haley.
Thank you, Madam Chair. I'd move we pass for the bill favorably.
Thank you. 2487.
I'm sorry, 2487 favorably.
Right. Is there a second? Second from Senator Olson. You all have heard the motion. Any discussion? Seeing none, then all those in favor signify by saying aye. Those opposed, no. The motion carries. And since we're also agreeable today, how about we take a look at House Bill 2490. And 2490, unless we're waiting for some amendments, 2490 is providing that each juvenile offender case length limit extension shall be for not longer than 90 days. Are we waiting for any amendments on that? Or yes, Senator Baumgartner.
Thank you, Madam Chair. I am waiting on 3 amendments.
Thank you. We are waiting on 3 amendments then, so we will hold off on working 2490. And thank you, committee, for your attention today, as well as staff for their preparation and their work here today, our conferees as well, and those following along in the committee meeting room and online. Want to remind committee and our conferees as well that tomorrow committee will have a room change. We will be meeting in 548 South. There is going to be in this committee meeting room tomorrow at 10:30 a hearing on a Medicaid expansion bill. Both the House and the Senate will be just a briefing. I'm sorry, not a hearing on a bill, but a briefing on the issue. And so we will be meeting tomorrow, Wednesday, March 20th at 10:30 in room 548 South. Committee, if we are able to get all of our work done and completed by Thursday, we will not be needing to meet on Friday. So we will be diligently working towards that goal and just want you all to keep that in mind. So with that then, want to thank everyone and the meeting is adjourned.